Good morning, and thank you very much for joining us. I am Yori Folarin. Hope you had a great weekend. Okay, well, my guest this morning, let's get that out of the way because I want to say a very fine morning to Akintayo Iwilade. He's a legal practitioner and commentator on public affairs, especially the legal ones. Thank you very much for coming on.
Thank you so much for having me. Always a pleasure to be here.
Indeed, same here. And we'll be joined remotely by another lawyer, Kabir Akingbolu, and that begins to tell you that maybe we've chosen, one of those legalistic kind of subjects. Well, I don't know, not really legalistic, but it will concern everybody. It should, well, I guess I'm saying the obvious. The law does concern everybody. When, after going and coming, as we say in Yoruba, it concerns everybody. But I'm talking here about politics and the proposal within the National Assembly, since a joint session of the National Assembly has come up with some interesting propositions that they will, go ahead with in the constitutional review that's ongoing. Now, one of the bigger ideas is that of the Attorney General and Minister of Justice, as we now style that office, whoever is in there. Now, they are proposing that, you can separate the two. The Attorney General is one, and then the Minister of Justice is another. That's just one of the ones that sort of caught my attention. Let me see if Kabir is on the line yet, because Kabir will be joining us via Zoom. I guess I can't say good morning to you yet. I'll be a bit patient, and that will happen. So, we'll start with Akintayo. There are other things, of course, as was reported widely in the press. The other one that interested me was this whole matter about independent candidature. We've seen this in other countries, especially in the US, but it's not been possible here. Now, it's not as if it's possible, but these are proposals. These are ways the National Assembly is thinking, and I would dare say that it's sort of matching with the mindsets or commentaries or leanings of commentators through the decades. So give me your impression of the constitutional reviews as they concern, for instance, first, the whole matter of the Minister of Justice and the Attorney General being separate ministers or separate high officials. Well,
I would have been more excited to begin from the independent candidacy point.
Well, go there if you want.
Yes,
go there if you want. That independent candidature business.
Yes, because that speaks very closely to democracy. But let me defer to you by beginning from where you said I should start.
Because I'll pick you up on those last few words you said, deferring to democracy, meaning that this other one doesn't have too much connection with democracy.
Absolutely not. So, so let's just speak to what doesn't really deepen democracy as such, which is the much talked about separation of the office of the Attorney General from that of the Minister of Justice. Of course, we get the general theoretical view of it that the Attorney General ideally ought to be the lawyer to the public.
Exactly.
And then the Minister of Justice ought to be more like a legal advisor to the government.
For policy and all of that.
The policy, the executive that it serves. But I think it's a distinction without any serious difference. Because is there any appointee of government or any elected official of government that ought not to really be there for the purpose of serving the public? Whether you are representing the government, whether you are in any capacity you find yourself in public office, ideally is your duty, not really to the public. Who else should you have a duty to if not to the public? But speaking specifically on whether this would amount to, I'm more interested in what it will amount to in a practical sense.
Sure.
First, the question is, if the offices are separated, I get all the arguments. The argument is that the office of the Attorney General oftentimes is considered as having been highly politicized and all of those sort of things, and that maybe if there's a separation, there could be some sort of workability around public interest in a much higher sense. But the first question I would ask is that who will the Minister of Justice be accountable to? The President, of course. Who will the Attorney General also be reporting to? Officially, it will also be the President. So except we are saying that the office of the Attorney General should now become elective, and there are examples like that in the US. There are some states in the US where the Attorney General is elected by the everyday people. So that way, you are not you're accountable to the people who elected you. Your office and independence is guaranteed because you cannot be unilaterally removed by the, I'm talking of the states now in the US, for example. So the governor of the states is the US Attorney General, the federal Attorney General is not elected. But for some states, because of course they run a far deeper federalism than the sham that we have here, you'll find that the governor of a state would not be able to remove.
Wait, now you said the sham. The situation we have here would have been enough.
Yeah. Yes, it's a sham because we pretend to run a federal system.
Okay.
But in truth, we know we are not running a true and genuine federal system in Nigeria.
Okay.
So, and I mean that can only be to lie to it or to itself. So, if you look at the way the system is then structured, if we have a situation where the Attorney General cannot be fired by the governor, for example, of a state, the Attorney General of the state cannot be fired by the governor. His independence or his or her independence in office, his tenure in office is guaranteed. Only then can they be able to take decisions that are completely independent of political considerations, except we are just being theoretical. If we are looking at the practical sides of all of these things, the real focus for us should be the quality of persons that we elect as our leaders. Who do we elect as our president, who in turn makes or is expected to make sound decisions, appointive decisions of the kind of people that will be there and whose responsibility will be truly to serve the public cause and all of that. So I don't see what, it's just looking more like the same old decentralization or increase of agencies. You say you have one, just create another commission. If there's a problem, you create another agency and all that. So all those things do not necessarily address this, because what do we, as an average Nigerian, what do I really want in my Attorney General? I want an Attorney General who is able to speak for the public good, an Attorney General who is able to ensure that public rights, human rights, rule of law is protected, an Attorney General who is able to properly advise the government on the due processes of law and ensure that the ideological basis of democracy, legally speaking, are properly advised to the government and allows the political institutions to take decisions within the ambit of the law. I don't think that a separation by itself necessarily guarantees that if the system that allows some of the impunities that we complain about, if the system still remains the way it is, I think that it is essentially more of the character of our politics, but than the question of bifurcation or any of those things, really.
Taking into consideration all you've said of an ideal case scenario with, in having an Attorney General, I would have thought, or is it too simplistic for non-learned people to think of the Attorney General as, in addition to what you said, lawyer of the public, lawyer to government, maybe, that he would be able, by the very nature and definition of his office, if it's a separate office from that of Minister of Justice, be able to check government if need be. He could actually, look, it's not the same, but judges do check government.
Yes.
When it is necessary.
Yes.
And I said it's not necessarily the same in that judges are not. But isn't that the kind of animal that the Attorney General would be in an ideal case scenario, where he's just about almost independent, because what use is he if he is not going to use the wealth of his knowledge of the law and procedures and all of that to just know that because of the people, this is wrong. This infringes on rule of law, democracy, and all those things we complain about.
Exactly. The point you made about judges checking government under the, I believe you are referencing the principle of separation of powers and checks and balances. Now, what you find in that situation is because judges, the judiciary by its conception, is actually meant to be a check on the other two arms of government. And of course, the other two arms too are also meant to be some sort of check around each other. Now, one of the things that would make it more practical and feasible for a dutiful judge to check the excesses of government is because of there is a measure of independence that the judiciary is presumed to have. There is certainty to some extent and predictability of tenure. in office, there's protection for and immunity for what you do or what you do in the course of your judicial duties. You can't, for example, interfere with how a judge interprets the law, so long as they stay within the bounds of law, of course, and all that. So, but that's not quite the same with an appointee of the executive arm of government. That's not the position.
Since you explained that it's not elective, that's not the proposal here, as it obtains in other jurisdictions.
Exactly. So it's not. So I don't see how. So I think that if, for example, why is this clamor about the separation? I don't think this clamor probably existed in maybe many years ago. For example, I imagine that in the Western region, even though some of us were not born at the time, I mean, I'm sure you were around at it, most likely around, but I mean, for someone like me, I wasn't around at the time. But from what we read from our history book, government texts, we know that there were attorneys general in the regions. There were attorney generals in the federal. I don't think this sort of clamor existed at that time. I mean, I do not have any recollection or haven't read anything along those lines. It means that at that time, there was a measure of confidence that the everyday people, the Nigerian society, had in the discharge of the functions and how the powers of the Attorney General then were being exercised and all of that. And what does that tell us? It just only speaks to the character and the quality of persons that were taking those offices, both the appointing authority and the appointed person and all that. So all of this separation of powers and all that sort of thing, separation of the offices, I still do not see, except there's something in that proposal that essentially makes it impossible for the person in that office, or makes the person in that office insulated completely from political interferences, political orders from the appointing authority and all those sort of things, that gives that sort of independence similar to what the judiciary has. Only then can there be a basis for
exactly
for the separation.
Quite frankly, it must be admitted that the judiciary is in a unique situation that has been woven into the very fabric of democracy, and as you pointed out,
very
so
well.
it's woven in there. But when you were saying what you were saying, I was comparing it with some other bodies. Not that well, the Office of the Attorney General, like EFCC, for instance.
Yes.
They're supposed to be independent. INEC, for instance, is supposed to be independent.
Yes.
And the headships of those organizations often do have the need to say from the rooftop, nobody is interfering. This is the way we are going.
Yes.
And once they have spoken, they have spoken. But I hear what you're saying. Let me ask your learned colleague Kabir Akingbolu, who is now able to join us. Good morning, Mr. Akingbolu. Thank you very much for joining us this morning. Okay then. Yori Folari in studio here alongside Akintayo Iwilade, your legal brother. I don't know if you guys use those kind of terminologies.
I'll call you my learned colleague.
Your
learned friend.
There you go. Now, you heard some of what he was saying, I hope enough of it, so that I can get... So I wanted to get your impression too on how big a deal you think the proposal is to separate the Office of the Attorney General from that of the Minister of Justice, so there will now be two people. Your colleague has just said here that it's very little difference as far as he's concerned. What do you think?
Funny enough, my position with this is in total the same. Because you see, I cannot see the difference. I cannot see the rationale. I cannot see the wisdom behind it, because the only reason given, the only substantial, or so the reason that was given was, okay, the Office of the Attorney General has been politicized. Who are the people that are politicized? Is it not the politicians? Are they not the members of the National Assembly? What are they saying? Even the Constitution that made the INEC, that made take judiciary for instance, it made judiciary to be independent. But how truly independent was the judicial arm of government? They still like to tinker with it. Even we can see it in the recent June strike. Up till today, they have not effected the memorandum of understanding that is signed. Now, when we talk about the Office of the Attorney General, now my problem is this: you have to now fashion out what kind of person, what are the factors to be considered in appointing an Attorney General. Is it going to be a career officer from the ministry? Is it going to be an outsider, from a private legal practice? Who is going to be the Commissioner for Justice? There is going to be a serious collision between the Attorney General and the Commissioner for Justice, especially given the antecedent in Nigeria of how it used to be. The Commissioner for Justice will want to stamp his authority on the Attorney General. The Attorney General will want to stamp his authority to be the one in charge of the Ministry of Justice. There's going to be a collision, and it will create more problem than solution. And I can tell you, it can only become worse. It can be better if they split it. And again, in a country where we are clamoring for cutting down the expenses in governance, you want to now, you want to bifurcate one single office. I don't think it can work for us. I think it is better as it is. And, actually, the Office of the Attorney General, unfortunately, is the only office of a commissioner and minister that was specifically mentioned in the Constitution, that there shall be, a minister of justice, a commissioner for justice shall be the Attorney General shall be the Commissioner for Justice. So I don't think we need to separate it any further. And again, there is a snag here. They are thinking they want to pass it. I doubt whether the thing will be able to succeed, even at the National Assembly. But if it mistakenly succeeds at the National Assembly, there is every likelihood that it might not succeed at the House of Assembly. Because by Section 9 sub 2 and 3 of the Constitution, you cannot amend any provision of the Constitution except with the concurrence of a 2/3 majority of the states. So you need at least 24 states of the Federation, the House of Assembly, to pass it again. The FCT again. So I don't see how they can
and then ultimately ultimately the president, no less, has to assent.
Of course.
The president finally has to assent. So thinking of those hurdles.
Exactly. So these are the hurdles. They are not likely to muster. If they are able to muster two-third majority at the National Assembly, they might not be able to muster two-third at the state houses of assembly, because they need at least 24 states, including this federal capital territory. So I don't see any reason that this one that can be justifiably reasonable for them to say they want to split the two offices. I don't think so. I think we are better as we are.
Okay, so thank you, Kabir. There you are. I have two lawyers with me this morning. Both of them are on the same side of the conversation. They don't see very much benefit to all of this. Maybe as the program goes on, we'll get other opinions. But it's interesting to know that people who are stakeholders, we all are stakeholders at the end of the day. Absolutely. But then people who can speak to it in an informed sort of a way are saying that it might not be too much more than what we have here. But the way people have been speaking through time, I can remember that for about 10 years, we've been speaking about people angrily saying, and by the way, that whole Attorney General and Minister of Justice thing needs to be split. But you guys have just commented on it. Okay, there are quite a number of things. It isn't the only thing. In fact, as you had said at the beginning, you were much more interested in the other proposal, which is that of independent candidature, now being able to contest primaries if any of these recommendations go through. Because and just in case anybody is joining us and hasn't seen the papers, we're not saying that these are now law. These are proposals. These are intentions of the National Assembly, but you also heard there that it's one thing for the National Assembly to have a proposal, have its intention, but there still is a procedure. It still has to go beyond the National Assembly all over the country. That is to say the houses of assembly, including that of the federal capital, and finally the president has to have his assent. I remember a friend said to me yesterday when this news broke that the president might be advised not to, not to agree, so to speak. But that was just a personal opinion. Now let's look at this whole matter of independent candidature. What you said, you were very interested in that.
Yes.
Why?
Yes, and I'll speak to that, and I hope we have the time along the line to also speak to the things I feel should even be in these proposals that are not there yet. But let's just speak to what is in there.
Sure.
Independent candidacy. I think that's a very fine start, unlike the other one we just discussed. Because one of the things that the everyday Nigerian has, some of our frustrations as everyday voters is that there are persons that we probably would believe that are the best for our communities in terms of providing quality leadership, policy direction with the clear ideological direction that we need to build our societies and our communities, but who for some reason might not be considered as maybe owning the so-called party structures in Nigeria and all of those things.
We believe the infrastructure.
Yes, and exactly, and all of those funny lingo that is so peculiar to us. I believe that the idea of independent candidacy is to enable outliers emerge. I do not think, of course, it is not going to be a walkover. It's not going to be a tea party to even get there.
No, it isn't.
But that also creates an alternative for people who, for some reason, might not be able to play in the murky space of party politics. Because no matter the pretense we make about it, we know, and even the players know, that the party system in Nigeria still requires fundamental reformation, because it is extremely monetized. It is embarrassingly monetized, such that it is hardly a contestation of ideas anymore. It is always a contest of who is able to pay what, who is able to buy who, and who is able to move funds around.
But wouldn't that still continue even in private candidature?
Yes, I do.
Independent?
Yes.
Because any way you look at it, it's generally known that political endeavors will cost a pretty penny. Any way you look at it.
It will. I agree. But it reduces it means that everyday people who are not who are not stuck up in all of this partisan, who are not steeped in the partisan murky waters, they actually can, put themselves out there in their communities, in the country as it were, in their states, senatorial districts, House of Reps, demarcations, wherever that is, and make a stake to say that they want to provide some sort of outlier kind of leadership.
And they
for
must
the country.
make an impact in those communities that you're talking about. This is not as if it's a rosy road.
Exactly.
Just because you say, I don't want to run on the platform of a party. No. You still have to get 20%, I believe, in the way the proposal is constructed at the moment, to be taken seriously as a candidate.
So I think that it's a good idea. The fact that it exists does not mean that those who still choose to run on the traditional platforms of party, in fact, the fact that you're even running as an independent candidate does not even make you more patriotic than somebody who is running with existing party structures. But it is important that that alternative should at least be available. And then let's see how we work it through. We know that it is not likely to be perfectly worked out, maybe in the first or second or third election cycle. But over time, with time, all of those things will become. So even if, we've seen it that it exists in advanced democracies, but oftentimes in advanced democracy, because the party system has been largely reformed to a significant extent, where it is the party members themselves, everyday party members who determine
the process has become highly refined.
It has become highly refined, okay. So it's safe to run on the parties.
Let me find what Kabir thinks about this. How about you, Kabir? What are your thoughts on this whole matter of the independent candidature option, which is being worked at now?
The provision seems to have given a right to them by the right hand, and they are taking it back from the left hand side, because you are saying that at least 20% of voters, registered voters in a particular location or geographical location where the person is contesting must endorse his nomination form. And even in an election since 1999, the highest turnout of voters that we have ever had has not exceeded 45% in all the elections that we have that have taken place. And now, if you are saying 20% should endorse, you are saying almost half of the people that will vote must endorse his nomination form. I don't know how many pages or how many volumes of that nomination can take. It is too cumbersome. As far as I am concerned, If you have given single nomination, independent candidature, fine. If you say at least 5 persons from each ward of the constituency, it will have been more reasonable. But 20% is a lot. It may not be able to muster it. And again, in Nigeria today, our political culture and political socialization has not favored, candidates. It has only favored political parties. That is why you see it's only the popular political parties that are, having people that won or that will ever win any seat on their platform. That's why we are only PDP and APC today. ABGA in the southeast and in some other places we have Labour. They are too few. Now, because of this, it will be very difficult. If you now say 20% to endorse it, now an independent candidate may find it difficult to even win an election. For instance, if you are saying in a presidential that 20% of voters should endorse the nomination form, it means across the country, across the state of the federation, probably. So, in 2/3 of the state or of the federation or of the local government, this is too much. And if except the candidate is extremely rich, now we are talking that our political space has been too much monetized. If this is the situation, to get an independent candidature, you will have to spend a lot because you need agents to work for you, you need people to work for you, and without a structure, it will be difficult, especially given the nature of our political consciousness or awareness. Okay. This is my position.
Oh, well, thank you very much for, preferring it and offering it to us, so it gives us something to, at least talk about, because I've heard these two positions now. And both of you, again, it looks like both of you are saying that, I don't know what the National Assembly is doing, but all these ones, there's not too much profit coming out of this. But the producer said what I should do is that go on a quick break so that when we come back, we'll continue the conversation and indeed open the phone so we can hear it from home. What do people think? Stay with us, please. Okay, welcome back, and we're looking at moves in the National Assembly, the proposals to amend the Constitution. It's an ongoing process, and at least we just singled out 2 of them. There are quite a number of them. I think about 50 something, but some of them just rose to the top, and we've talked about that. We've spoken about the splitting up the office of the Attorney General, Minister of Justice, and Attorney General into that of 2 high-ranking officials. We've also spoken about independent candidature, and the 2 lawyers with us, Akintayo Iwilade and Kabir Akingbolu, by and large, don't see much profit in either of those for the moment. But the phones are open. We need to hear from home to see what people think as well. And in any case, it shouldn't be thought that these things that we're talking about are anywhere near coming into force, because this is still the talk stage, still the proposal stage. After, if they can get through it in the National Assembly, getting them to agree among themselves, you still have to go right around the country and get 2/3 majority in all the states of the Federation. And then you have to get the president to agree. That's not something you can put money on. Yes. That just send it as soon as it lands on his desk, he'll sign it. Yes. So either way. Okay. Good morning, Mr. George.
Good morning, Uncle Yori, and greetings to your guests.
Yes, thank you very much.
Good morning, sir.
Uncle Yori, to start with, the ideas the National Assembly is coming up with, they are good ideas, but given the experience we have seen recently, do they have the lever to push it through? I told you that direct primary that they put into the Electoral Act was a platform for generational change in this our country. But when the chips were done, they chickened out. They couldn't stand the pressure from the executive. Now, what we are having in that act is the same old story. Coming to these ones, these are very good ideas. This is why, Femi Gbajabiamila, the Speaker, and the Senate President, they are coming up with good ideas. But would they be able to push it through? That's the thing. I do not agree with the other gentleman that says it is impossible to do. You have to try something before you give up. We haven't tried. Let us try it and see where it will go. Separating the Office of Attorney General from that of Minister of Justice is a possibility, provided what the gentleman before you there said, provided one of them, that is the Attorney General, becomes elective. It is possible. Why is it not possible? Let them try it first. If we are able to push it through with public discourse, it will come to it may not be a one-day thing. You push it through one session, it doesn't work. You push it through the next session, it might work. Maybe up to the fourth session before it works.
Okay.
Those who are having it didn't get it in a day. As for the independent candidacy, yes, that's one of the reasons why I was pushing for this direct primary. There are many people that are very good materials for governance, but they are not able to penetrate the party system to emerge as candidates. They don't have much money. They don't have the know-how to be able to, get themselves through that tight system. If there is provision for independent candidacy, you can see that they will try it. Uncle Yori, let me just brief you on this.
Sure.
I went to INEC portal during this voter registration renewal, and I discovered that over 20 million people have been registered in this drive, and 64% of them are youths, because they were given the opportunity to register online. If direct primary were to be put in place and you put this digital format as a platform, you would be amazed, Uncle Yori, on the result we will get in terms of participation of younger people in our political process. Somebody like that gentleman, beside you, will emerge if the platform is provided, so that there will be new form of thinking in governance in this country. I want to believe that what Femi Gbajabiamila and the Senate President are pushing through, they are good ideas, but let's give them a trial.
Okay.
They should not chicken out again, just because they don't want to disobey the President. That's where my fear lies. But the ideas are good.
Okay. Well, thank you. Thank you, Mr. George, for calling in. Let me, there are other aspects, and I want to touch on about 2 or 3 of them, sort of maybe remotely related to this particular subject matter about that we're talking about now, this independent candidature. It's not quite the same, but this whole matter about reserving certain number of elective positions for women. Let me kick that off from Kabir. Kabir, take hold of that. What are your thoughts on by law reserving certain number of a portion of situations of elective positions for women?
Well, it is a welcome development, I can tell you. But then how they will not, how we are not going to abuse that privilege is another thing that worries me. But I think it's a very wonderful innovation. We should commend the National Assembly for this innovation.
What is the possible? However, what is the possible abuse? What is the possible abuse? Putting my daughter there, putting my wife there, putting my mother there. Is that
exactly? Oh, okay. Exactly, because the people, the politicians or the forces, especially when they are in power, since it is reserved for women, it is not likely for anybody to contest it with them. It is possible. They just say, oh, we are going to give it. They might give it to their wives. They might give it to their subordinates. They might give it to their relations. This is the thing, because now it's a closed circuit contest. So it gives them the room to now dictate who becomes what. So the primaries will even be, if they are going to conduct a primary, it's going to also be a closed circuit thing. So if this is not going to be abused, I think it's a wonderful innovation because although under the law that we operate, there is no law or any practice or code that says a woman cannot contest for any post. But we find it that naturally they are just not meeting up to the same level with men. So that is the reason for this innovation. And given the peculiarity and complexities of our political, space, I think it is a welcome development, and at least to encourage the women to participate more in politics.
Yes.
You can, if you remember very well, it was during the time of President Jonathan that he said 35% of posts, political posts in his administration will be occupied by women. And he started. And again, to go further again, in Nigeria...
Well, sorry, you'll be able to go further. I'm going to come back to you. Sorry to interrupt you. I have Reverend Dominic on the phone. So just before I come to you, Akintayo, let me get Reverend Dominic's input. Well. Good morning, Reverend Dominic.
Good morning, Yori.
Thank you. Good morning.
Good morning to your guests in the studio and the guests on the line.
Sure.
Good morning, sir.
Yori, let me start from the Attorney General office.
Yes, okay.
Yori, it is common knowledge to every one of us that this democracy has been so expensive for us, especially in Nigeria, that we are borrowing money to sponsor our budget. I think what they could have done is to empower the Office of Attorney General in this way. The problem the politicians are quarreling with, or most of us are quarreling with that office is this: that EFCC or police may take somebody to court. Maybe the man they took to court today may become maybe to the ruling party tomorrow, and the Attorney General will withdraw that matter. What they have to do is that when any agency like police or ICPC or EFCC take somebody to court, that the Attorney General will have no power to withdraw it until that matter run its course. That's the way to pass that office, not to create a bureaucracy. We are creating a bureaucracy that will cost more money and money. Let me give you an example. In Niger Delta, we have 3 intervention agencies to cure lack of development. Have they cured it? Ombadek, NDCC, Niger Delta Commission. All of them want to end up creating more bureaucracy that consume more money than to solve the problem. That is, by the way, an independent candidate, either they want to create it or not, they should put impediment to it. If you say I should contest the election, don't put anybody to come and sign my form. If I throw myself to the public, it's either yes or no. Why impediment? So most of these laws may be sued in the paper, but it cannot pass through the state assemblies because of the bogus of it. They should make it simpler so we can have a good constitution. That's my contribution this morning. Good morning.
And I thank you very much for it, Reverend Dominic. Now, Akintayo, let me get your take. Kabir is quite enthusiastic, all other things being equal, as he said.
Yes.
Your thoughts?
I would say that it would be much easier to begin with appointive offices, in the sense that I think that it shouldn't even be 35% or 20. I think it should be 50-50% actually. That is what is equal. That is what promotes equality in society. That it will be easier for us to constitutionally legislate that appointive offices, that at least that is within the control of the appointing authority. 50% of it should be for the female gender, 50% of it should be for the male gender. That's what I think.
That's in the case of appointive. But the proposal being considered, deliberated upon, is elective positions.
But in the space of elective office, it will be good to see what the framework is like. So let's take a practical example.
Wait, before you go to that example, hold the thought. I'll come back to you so that I don't delay Ada in Jos, who has called in. Good morning, Ada in Jos.
Hello. Good morning, Mr. Yuri and your guests.
Indeed.
Ada calling from Jos Plateau State.
Yes.
For me, the splitting the positions of Minister of Justice and Attorney General, for me, it doesn't really matter. What matters is strengthening our institutions, so the office holders will discharge their duties efficiently without much interference from the executive arm. Moreover, one man carrying out both functions will save costs rather than separating it and increasing our bloated overhead costs. Will splitting expect the flagrant abuse of the rule of law and making pronouncements that imitate the sensibilities of the masses? Your guess is as good as mine. So for me, it doesn't really make sense. Okay. Now again, now trying to bring in the independent candidacy or whatever. There's nothing wrong with that, but is this percentage in the number of people percentage that should endorse it? That's what I am quarreling with. Left for me, if I had my way, they should have just left it open. Then for the women's sake, as much as I'm a woman, and I feel that we should be, the seats should be reserved for us, so that everybody contesting for that seat will be a woman, so that at the end of the day, a woman will emerge, to bridge the gap of the 35% affirmative or whatever. But what I'm against is this of having a separate list. Let them an additional number to what we have already. If we have 3 for each senator or whatever, let's 2 do for men and 1 for women. Let them do it like that. Then adding another 100 or something. On it. That's a lot of money. So I don't know. Are we going to keep on borrowing to run the National Assembly or whatever? All this, let's not give up this country.
Thank you, Ada. Thank you, Ada, for calling in. Okay, now,
so
yes.
I spoke about appointive offices, so that should be easier. Now, but in terms of elective position, a practical example, even taken from what the last caller just mentioned, look at the office of the president, for example. The Constitution says you must have a president and a vice president constitutionally. So which of those positions are you going to reserve by law for the female gender and for the male gender? Just to start with, because you can't be
rich like that.
Yeah, we can't be talking of equal representation and we're just talking of legislative positions alone. Now, also go down to even the legislative offices. These senatorial zones. For each state, we have minimum of 3, I believe, constitutionally. So, which of the zones are you going to say must be for the male gender? Which of the zones are you going to constitutionally outlaw one gender from contesting in, and then insists that the only people who can contest in XYZ zone would be male or would be female, and then in this zone it will only be male or female? When you look at the practicalities of use, you will find that there is some bit of more pragmatism that we need to consider. But apart from that, the bigger question about gender discrimination in society is really not, apart from all of those issues which are very important steps towards it, what are we doing about the subject of all of the cultures that fundamentally discriminate against the female gender? What are we doing about all of the, the ideas, even religious ideas that fundamentally step down the place of the female folk in society? Are we really ready for those conversations yet?
So to speak, our charity in this case should go and begin at home.
It should begin
before
from
we
home,
reach into
from
the
religious
political
houses, from the cultural
offices.
systems. If you look at through the gamut of all our laws, there are a lot of gender discriminatory laws in our laws. Have we taken time to begin to take those laws one after the other? Because those are the things that are really bringing down the potentials of the female gender.
Harsh with the National Assembly,
and all of that.
and they're trying their best.
But I just want to, Uncle Yori, I want you to answer that question, that for the post of the president and the vice president, how will this proposal of the National Assembly work? Which position are you going to outlaw?
You want to ask me?
Because if you say...
Don't ask me jam question. Mr. Kesandu, good morning, sir. Thank you for holding on. I dodged the jam question. Carry on.
Good morning to your guest.
Good morning.
I want to align myself completely with your guest as regards the issue of Minister for Justice and Attorney General. It's unfortunate that some persons or the senators or members of the National Assembly do not understand, or that they don't want to appreciate the country we found ourselves. What are the parameters to distinguish between the two? Not workable. It is not feasible. It is not practicable in our present in Nigeria. It is not going to work. That's just the gospel truth. Please, I want the National Assembly, there are certain things I want them to look into. For instance, the issue of when they talk about raising the money for the what you're going to spend for the national election, it is too much. I wanted this time around that the members of the National Assembly in this new electoral act, can we bring down the cost of purchase of nomination forms? That has become necessary in our politics. How can for a House of Assembly, you see a political party charging ₦1 million? Why? It is high time Nigerians understood perfectly that this is a pure call for service. And when you spend so much to go into this power, and that is when you see corruption and looting, we must make this thing be purely for service. Secondly, let us have this, especially these things, as part-time basis, especially those of them for the legislative business. Can we have it as part-time basis? So that if you're coming from Imo North now to Abuja to do your business, after the business will pay you for the services, for the sitting allowances, you go back and do your business as a normal Nigerian citizen. It is not supposed to be a full-time business. Let us bring the money down for this nomination forms. For instance, House of Assembly should not be more than 300,000 naira. It will give credible and competent people a chance to participate.
Okay, Kesandu. Thank you very much for calling in. Appreciate your contribution. And because I want to touch on at least one other aspect of it, this one I don't think the lawyers are going to have any problem with it, but you can never tell. Let me go again to Kabir. Kabir Akingbolu on Zoom. Look, the National Assembly doesn't want us to parade, that is the police, DSS, NDLEA, whoever, other agencies, to be parading suspects, as we often do. That will be outlawed. Your thoughts on that?
Yes, actually, by the constitution that we operate under section 36, I think, is every accused person shall be presumed innocent until the contrary is proved. That is what the constitution, has provided. But the police, the NDLEA, the NSCDC, the custom, the rest of them, EFCC, ICPC, they keep on parading people every day. And these people are mere suspects. And eventually, even the next day or the third day, the true light may even come and these people may not even be charged. But you have damaged their reputation. And in this era of social media, if you have forgotten, social media never forgets. And it has damaged the reputation of the people forever. Now, I think this is a very fantastic innovation. Maybe, now that we will have it in a constitutional provision, maybe the police or our security or investigative agencies will be able to comply with this law, since it is now direct. But
okay. Kabir, I beg your pardon, Kabir. Thank you very much. I'm going to have to put a slight pause on it so I can get Akintayo's input on this whole matter. I was, saying that lawyers are probably going to be happy with that for the very reason Kabir is talking about. You're presumed innocent until proven otherwise.
There's something we use in our everyday courtroom language that I align myself only with the position of my learned colleague on that point. We're on the same page, absolutely on that point. It's just the rational thing to do, is the appropriate thing to do. So I rest my position on my colleague's learned colleague's position.
At least that one, I don't think anybody's going to call in and say that that one is not working. But for all, I guess it bears repeating. What we're talking about this morning are proposals. Proposals to amend the Constitution that the National Assembly is working on. But as I said, there are quite a number of them, but just selecting these three for the sake of brevity and the proportions of the program. We can't do more than that. So I don't know what you think generally. They're busy. People say, there are people who are saying that they should not even be full-time, but at least, are they on the right path in terms of trying to put action to some of those commentaries that they might have heard right down the years?
Yes, I think it's commendable that at least some efforts or some thinking is going on, but beyond the thinking that is going on, so that it doesn't just end up, because we see that this ritual repeats itself almost like a 4-year cycle. Every assembly says I'm amending the Constitution and the country still remains the way it is. Maybe because we are yet to touch on the real critical issues that the people are more concerned about. For example, the very subject of true federalism in Nigeria. If we look at that, the current constitution we have about 68 items in the exclusive legislative
that's
list.
That's a big question you just brought up, that you can't even go there.
Exactly.
Because not when we have seconds. But it's an important issue.
Very important.
Is why you brought it up, that there are some of those things that you said you would have liked them to, pay attention to, that
like
they
state
are not.
Police,
decentralizing
power, devolution of powers.
Now talk about those ones.
Those are the things that we want to see in this proposal. Yes, those are the real things we want to see.
Your thoughts on this, Kabir, as he says, well, I got me an extra guest in there. I didn't quite understand who he was. But Kabir, if you can hear me, again, do you align yourself with the positions of your learned colleague? Oh dear.
There is nothing to add in that respect. But I think, again, in respect of appeals, I think it is not all appeals that must get to our Supreme Court, because we have only one Supreme Court in Nigeria, serving 36 states. There should be an amendment here. There are only few cases we get to that Supreme Court. or if there is going to be regional Supreme Court, let us know, because our justice delivery system is too low in this country.
Okay.
We need to do something about it.
Okay. Thank you very much. I appreciate your making time for us this morning, Kabir Akingbolu. He ended up on that whole, again, as we mentioned at the top, that, look, in some places, they elect their attorney generals. And then also in some places, you have regional Supreme Courts.
Exactly.
You know,
exactly.
But there's just the one for us, and that's what he, sort of remembered.
Yes.
Okay, we're going to have to leave it here. Thank you very much for being with us this morning. Please join us tomorrow. Our thanks to Akintayo Iwilade and Kabir Akingbolu this morning. Join us tomorrow for a fresh edition. I'm Yori Folarin. Bye-bye for now.